Thank you for viewing our Smart Talk recording, What Happens When a Borrower Files for Bankruptcy. Information about bankruptcy is always a topic that arises from students and even aid administrators when determining aid eligibility. In most cases, aid is not impacted as long as the student is not in default on a federal student loan. However, in the media lately, there has been some talk about how loan servicers discuss bankruptcy with loan borrowers and their options to either have their loans discharged or avoid the bankruptcy path altogether. In this Smart Talk, we want to provide some clarity on how servicers handle borrowers who have filed for bankruptcy. Ultimately, we must understand that loans can indeed be discharged in bankruptcy under the terms that the borrower has an undue hardship, which we'll discuss in detail in this Smart Talk. So a student comes to your office and says, I have filed for bankruptcy. What does that mean for my student loans? It's a common question, but think about some of the things that you are saying to your students when they ask you this. Are you replying, bankruptcy has no impact on your federal student aid loans? Or you're okay as long as you're not in default? Or even your loans are impacted because of you filing for bankruptcy? In the end, you'll want to make sure that you have a response to this question when it arises on your campus. Over the past 5 years, bankruptcy in the United States has decreased. In 2014, there were 936,795 bankruptcies filed nationally compared to 1.5 million in 2010. One common myth about bankruptcy is that student loans can never be discharged. I'm sure you've heard it before too. However, what do you think? Is this something that you hear all the time on your campus? Or is it something that you hear sparingly as students are coming into your campus? Of course, if we were to really evaluate this, we know that it is indeed false, because student loans are indeed dischargeable under rare circumstances. When a borrower files for bankruptcy, their legal representation, so their attorney, should inform them on what things can be discharged. If the borrower is not aware of the things that are not dischargeable, on the back of their loan discharge paper, there is a list of items outlined. On this slide, we provide an overview of some of the non-dischargeable items, and as you can see, debts for most student loans is included. This is where we suspect the wrongful interpretation that student loans can never be discharged started. The Department of Education has stressed that bankruptcy is an option for students. However, it is very hard to have federal student loans discharged because the borrower must prove to the bankruptcy court that repaying their student loans would cause an undue hardship. This undue hardship is based on the borrower's household, so their wife, their husband, and children, etc. And to determine the hardship, there is a three-part test that is used. Now, that three-part or three-point test that the bankruptcy court uses in order to establish if a borrower is eligible to have his or her loans discharged in bankruptcy court. When the bankruptcy process happens, the borrower's creditors may be present to challenge the request, so the Department of Education may be there to counter the claim of an undue hardship. However, the three factors that are used are based on if the borrower would not be able to maintain a minimal standard of living for their household, if there is evidence that the hardship will continue for a significant portion of the loan repayment period, so this might be due to some type of illness or disability, and also the borrower made good faith effort to repay the loan before filing bankruptcy. The Department of Education states that usually means the borrower has been in repayment for a minimum of 5 years. The borrower must be able to satisfy any one of the three requirements. If the loan is discharged, the student may not have to repay any portion of the loan or the entire debt, and all collection activity will stop. as long as the student remains current on any remaining balance. Now, we want to point out that not all courts will use this as a means to determine an undue hardship. Judges will have their own interpretation as to what is considered to be eligible. For example, say a Judge Joe Brown might say 20 loan payments constitute for good faith efforts, and Judge Judy might say 50 loan payments constitute for good faith efforts. It's all concluded with the judge's interpretation. So despite recent myths, loan servicers want to do everything in our power to assist loan borrowers. However, by law, there are only certain things that can be done during this delicate time in the borrower's life. In the aid office, a student might be able to receive Title IV aid as long as they haven't defaulted on their loans, but it's different for loan servicers. So when it comes to bankruptcy, Great Lakes and other servicers do a few things to protect the borrower and ourselves from receiving incorrect information. When or if a borrower contacts us about bankruptcy, a bankruptcy hold is placed on the borrower's account. This hold lets us know that the borrower has filed for bankruptcy and for us to verify that they have a case within the court. In rare situations, a borrower may call their servicer and say, "I filed for bankruptcy, don't call me anymore." However, this must be verified in a specific manner without violating bankruptcy laws. Due to the bankruptcy laws, any legal advice must be obtained by the borrower's attorney. Servicers will not provide options on what they need to do regarding their status. However, we know that student loans are extremely hard to have discharged within the courts. After placing the hold on the borrower's account, a system called PACER is used to verify all cases that have been submitted for bankruptcy within the United States. When this is verified and valid, a verified bankruptcy hold is placed on the borrower's account. Doing this suppresses any means to collect on the student loans until determination of the discharge is made. The timeline of this varies depending on the type of bankruptcy filed, like Chapter 7 or Chapter 13, and it can take up to 6 months in some cases. The verified bankruptcy hold stops past due notices, correspondences like letters, emails, and calls, also credit reporting, so once the bankruptcy concludes or the claim is paid, the credit reporting agencies will be updated. And this hold remains until Great Lakes receives notice that the bankruptcy has been concluded. So as we wrap up, this Smart Talk session on what happens when a borrower files for bankruptcy, as financial aid administrators, it's imperative to keep a few things in mind. Borrower situations are delicate and require assistance to resolve, and sometimes that's additional assistance to be resolved. Be patient because sometimes it will be difficult to talk about with students. Connect borrowers with their servicers, discuss their situation if it's needed. And also be familiar with different options and resources that can reduce loan delinquency for students. The Federal Student Aid Handbook is a valuable tool that provides a lot of great information, primarily information regarding default and bankruptcy. It can be found in Volume 1, Chapter 3, when it comes to reviewing that information. So thank you for watching our Smart Talk session on what happens when a borrower files for bankruptcy. We hope that this information was beneficial for you.